Cory McDowell has been very generous to join us today. He's also a native New Mexican, born and raised in Albuquerque. He did graduate from our UNM School of Law in 2015, and then afterwards practiced litigation defense for 4 years before coming in-house to UNM. He currently works on a broad range of health law interfaces for the entire UNM system, including supporting many of us who are navigating legal interactions with families and patients. He's currently the liaison for the UNM Medical Group, corporate secretary for the UNM Medical Group. And when not practicing, those of you who saw his beautiful family, he spends time with his wife, Laura, and their 3 little kids. He enjoys golf and grilling in his rare free time. So welcome, Cory. We're so excited to have you today. Like I said, I'm sure there will be a lot of questions, but we'd love to have you just jump in and start, and we'll have time throughout to, if people have questions, to jump in. So please.
Well, thank you very, very much for letting me be here. I know rarely are people excited to get to speak to the attorney. So I know it's a big ask, and I do appreciate your time. And it's one of our big goals for our office to get to know more people and to be more visible so that you all have contacts and faces and you feel free to contact our office when needed. So I really appreciate it, and definitely want to say a big thank you, Dr. Kane, to all your work in this and giving me some topics. I did prepare some slides and some topics to answer a few of the questions I have. I'm also prepared to talk about some of the few issues that come up around testifying or subpoenas or some of the other areas where things can get pretty sticky. But I do want to leave as much time as possible for questions, and I want to welcome any questions at any time. Obviously, I probably won't be able to look at the chat the whole time I'm presenting, but feel free to write your questions if someone can keep an eye on that for me. Otherwise, feel free to unmute and just ask questions. I think a dialogue and conversation is often the best way to learn. And so welcome any questions that people have for that. All right. So I guess I will start with hopefully sharing a PowerPoint presentation. Is that what people are seeing? Beautiful.
Looks good.
So I like to always start off. I know there's quite a few, there's a broad range of folks on the call, which is great. But I do want to give a little bit of background and introduction to our office, the Office of University Counsel. Different institutions, it goes by different names, but we are the legal entity and the lawyers who represent the health system and also main campus as well. So a little bit of background on who we are and kind of what it is that we do, so you can get a better picture of that. And then there's a few topics, like I said, that were raised as coming up quite often that I think we might be able to have some good discussion around. And then if time allows, we can talk about some different types of testimony and how to prepare yourself and what it is that our office can do around those types of different issues there. So this comes directly from our website and who we are. As I said, we provide the legal advice and service to all of UNM. So technically, our client is the regents of the University of New Mexico. We have an office on both sides of campus. Our HSC office is actually in the HSSB building on the 3rd floor, right next to, or right down the hall from Dr. Ziodonis and some of the other admins there. So my office actually backs up to the psych emergency area and share that parking lot. So we have 7 attorneys on our side, health system side, 9 on the main campus. A lot of the main campus folks do get involved in the HSC side as well. We don't have the typical Lomas divide, but it's just a delegation there. So like I said, we do provide services to everyone. Obviously, Sandoval Regional is no longer there, but we still provide services to them through the hospital, as well as all the research, academic, clinical partnerships, and then the health system with the hospital and medical group. Just to give you an idea of kind of a typical practice or where it is that we're doing. Our office doesn't just do med mal. We don't just do one area. We do have a team of 3 attorneys who handle almost all exclusively medical malpractice litigation and claims that come in and helping guide those. But there's a team of 3 to 4 lawyers who really handle just about everything else you can think of that might be related to a hospital. So I put as much as I could here, but there's a lot more that come up and things that we're learning and dealing with every day. So we always welcome questions for anyone who has one, who would like to reach out. In addition, one of the things that I didn't put on the slide, but I want to make sure that everyone here is well aware of, is our office has an attorney on call 24/7, 365. And so we are available for emergency questions. If there are issues after hours or even during hours, we're available through the Tiger system. We all have Tiger text, so you can text us and reach out. I think if you go onto the app on your phone, we're listed under attorney. But if you go online to the web portal, we're listed as University Counsel. So we didn't intend to make it difficult to find us, but I promise we're there. If you do a little bit of digging with either of those code or keywords, you'll be able to find us. So if you ever have any questions, feel free to reach out. Okay. So jumping right in, the first kind of question or issue that was raised was in regards to a situation where a child is brought in and there is suspicion or belief that there might have been some type of abuse. But the parents indicate that CYFD has already been called, that the report has already been made. Do we then have to report as well? And so I put up here the duty to report statute. I'm sure most of you are very familiar with this. Everyone practicing is a mandatory reporter. It's pretty clear, and that shouldn't be too much of an issue. But the way that the language is phrased in the statute, it says that it shall be reported. And so it's my advice and the advice of our office that regardless of what the parents say, we make a second report. If it's a second report, CYFD can say, thank you very much. We're already aware of the situation, and they can move on. The thing that I want to always make sure that we're aware of is it's technically a misdemeanor to fail to report. And I don't want anyone here to be put in that type of hot water. So when in doubt, report. Even if they say, your next door neighbor or another provider, someone in the emergency room reported, doesn't matter. If you believe that this needs to be reported, make the report. And if it's duplicative, so be it. I know that there are definitely times where then individuals get threatening. And that's one where I want to make sure there is a policy on security's role in patient management. That's the title of the policy. There is a process and a procedure for getting UNM hospital security involved and make sure that they're well aware of what's going on. We had a situation not too long ago where it went from UNM security to UNM police to APD. And we had an APD escort a father out of our PICU for getting a little bit threatening to our providers as well as the CYFD workers. So please don't hesitate to reach out and do that. I know there are some instances where it can be difficult to get through to folks. If you need help getting the right people involved, feel free to reach out to our office and we can help coordinate who needs to be involved. But in those situations, UNM hospital security should be on hand to make sure that everyone's staying as safe as possible. So I guess to start with, does anyone have any immediate questions on reporting or questions around that area they want to make sure we touch on?
I think, and I'll double check the chat. So occasionally, not occasionally, we will have families saying, oh, we did have CYFD involvement 5 years ago, 2 years ago, but a year ago, but the case was closed. What are our obligations at that point?
So regardless of what happens with the case with CYFD, our obligation is to report. Um, and it's to report who knows or has reasonable suspicion that a child is an abused or neglected child. So if there's something that came up, we can always call CYFD and ask and verify. If this matter has been investigated, perhaps if during some kind of session they disclosed to you that there was prior abuse that was investigated or prior instances or something like that, we can always reach out to verify before making an official report. But if there's any doubt, I want to err on the side of over-reporting rather than under-reporting, because that's going to protect our providers from any type of situation.
I think one of the things, and I'll speak to our folks who work in PES, couple of things, and they see probably our most fragile families, and then not infrequently CYFD is involved. And there are many times you have to be on wait for a really long time. And when they're inundated with patient after patient, I can see that is a barrier. I think the other barrier is in terms of it depends when you call the number, the person may or may not give you any information. And very frequently when I've called, they said they're not allowed to share that with me until the case is closed. And if the parent allows me to have that information.
Yeah, if those type of instances come up, again, we can try to help coordinate and getting the information that we need. Unfortunately, CYFD is one of, if not the most underfunded and understaffed departments in New Mexico, and that's probably saying something. I think last time I had looked, they had over 900 job openings posted. So we have issues almost all the time with having the right people on board. There are times where we've gone straight to their general counsel. I think right now they're in between general counsel because they can't keep someone there. So we definitely try to use our resources to help out. We got to do everything we can and document in our records the steps that we took. So if they're not answering the phone, if we're trying to get through and make a report, if we can document and maybe set a reminder to follow up at some point, or again, if something's going on, you just cannot find anyone, we may be able to have some resources to contact and get the right people involved.
And there's a message for you or a question. So what is the clinician's duty to notify the family or relevant members to the patient, so family and whoever's part of this patient, that CYFD will be called?
So I think it's honest and good to inform them of the fact that you are a mandatory reporter. There is no duty to notify the family that I'm aware of. The duty only is to notify and make the report to law enforcement or CYFD. But I think it is always just an honest patient building thing. There's nothing that prohibits you from indicating to the family or being honest with the family that this is what I'm required to do. I have to take this next step and this is what's going to happen. If that's going to help build patient trust with either the patient themselves or the family, there's nothing wrong with that. But there's no outright duty that I'm aware of to report that to the family before you make the report to see what I do. But thank you. Good question.
I have a question for you, Cory. Can you hear me?
Yes.
So I just sent it in text. Two things. One, I'm wondering why our policy is more stringent than the actual statute. The statute requires contacting CYFD or law enforcement. It does not require both, but our policy requires both. And the reason I'm asking is because, like, I've worked with children and families, and we have many children who are citizens here, but their parents are undocumented, or their grandparents or extended family, and calling the police, having the police come out to their home is extraordinarily traumatic for these families. And it really jeopardizes the therapeutic relationship and really prompts many of them to discontinue very, very needed services for their children. And it's not even just undocumented. We work with a lot of families that have had encounters with different institutions or enforcement, have a lot of, for lack of a better word, negative associations, justified or unjustified, where calling APD does facilitate a trauma response in them and ruptures the relationship. Whereas CYFD coming out does not seem to sort of trigger that kind of response of fear.
I think that's a great thing to bring up. I was unaware that our policy required both. And I think that's something that might be a good thing to bring forward for review on taking a look to make sure that we have the best policy that we can. Because I was unaware that it required a report to both.
Well, the way it's written, it seems like, the way I read it, it seems to require, the first part, and then A or 3, because maybe I'm misreading it, but that's the way it's been interpreted to me.
That might be practiced differently. I'm pretty sure it may be. I don't know that everyone has that understanding. I don't know if that's the current policy. Cory, that may be helpful to give us some guidance about that.
Yeah, I'm gonna go ahead and I'm making a note right now to go ahead and pull up
Thank-
that policy and take a look. And that's something that I'd be happy to follow up and get you some guidance on that and see it, like I said, if it's being misinterpreted or if we do need to possibly update the policy to make sure that we're following the best practice we can. So, thank
Okay.
you.
Thank you. Appreciate that.
So continuing on, I think one of the areas that I get questions most often around this type of thing is whether or not something constitutes abuse or constitutes neglect. And so I did bring in the definitions. They're included in statute. They're probably just about as vague and unhelpful to you all as they are to most. It's the nature of statutes. They have to be written for a broad audience and for broad reasons. But they do have definitions that are available. I'm happy to share the slides or provide the citations so that people can actually take a look at where things are. Most oftentimes, when there's a question around whether or not abuse or neglect exists, it's our office's job not to tell you whether or not it does, but to support whichever decision you want to make. And so we'll help you walk through documenting, talking to other providers, making sure that you understand how to defend your decision one way or another, and perhaps maybe walk through some of these definitions with you in real time in case there's kind of that back and forth of do I or don't I, and then we can make a decision, help you kind of navigate some of those waters. So again, this is the definition for an abused child. Lots of gray area, lots of different things that go on with this. A neglected child, same thing, lots of ambiguity. One of the downsides of being in New Mexico is we're a relatively small population-wise state, and we have relatively little litigation. And so there's not a lot of case law that's developed in New Mexico to give us a little bit more guidance within some of these that there might be in places like California, Texas, New York, where there's a lot more case law that can develop some of these ideas a little bit more clearly. And one of those big areas that I think has been raised is around corporeal punishment. And that is not mentioned anywhere that I can find in New Mexico case law or in any of the statutes or anything that's around that.
Cory, this is Avi Kreichman. I'm a child and adolescent psychiatrist on the faculty. One thing to be clear about is that New Mexico is reasonable suspicion. A lot of states say evidence. So the way that the law is written, you err on the side of if it's vague at all, you still have a duty to report.
Correct, and that's the language here in the original duty to report statute, knows that it has a reasonable suspicion. So absolutely, it doesn't have to be proved. We're not standing up saying we know that there is abuse. But yes, reasonable suspicion. If you can support that, then that's your duty to report that. Very good clarify. So like I was saying, with the corporeal punishment, it's not mentioned. No one's brought a case around it as to whether or not it does. There is national guidance from some ethics centers and some other different sources who have tried to tackle the subject. And there seems to be a national general consensus that corporeal punishment in and of itself is not abuse, but that there seems to be some type of spectrum where when it crosses a certain line, it may go into that. So again, that's an area where discussion and particular facts and reasons why we might believe there is or is not abuse if we cross that line. We'd be happy to help you walk through that, make sure that it's documented in the record so that you can show why you had the reason of suspicion versus why not. Any other comments or questions or some of those areas? No. All right. So the
Actually,
next,
I have a comment on that. Sorry.
sure.
I guess what I was sitting with was, I guess racial bias, if I could put it that way. When we have a vague, sort of a murky law, I feel like it opens the door to our own biases coming into play as to when we think that it's crossed the line into abuse. I don't know if you have anything to say on that, but I felt like it was worth saying.
I think it's something that's worth being cognizant of as you're developing your opinion. It's not necessarily something that's contemplated by the law. Unfortunately, when we look at things, we have to draft in a certain way. Otherwise, statutes become useless, or we have 500-page statutes that are just as useless because we can't actually get through them and understand all the ins and outs. But I think it's a great point that you raise. There's always concern of that. And I think sometimes having a conference with colleagues or having a conference with our office, again, if you have questions and you're concerned about some of those areas, may help you to draw out some of those and be able to decide, am I basing this off some inappropriate bias for whatever it might be? Could be race, could be religion, could be all sorts of different things, backgrounds and characteristics of folks. And so that's something to be aware of, but again, not necessarily contemplated in the law when it comes to that reasonable suspicion. Yeah, but great comment. I appreciate you bringing that.
Actually, can I ask a question? And I apologize if I have the details of this wrong, but because I think I just read it in the paper, like that, like Johns Hopkins, there was a lawsuit where I think they had reported a mother for suspicion for Munchausen's by proxy. Like the child was removed from their custody. I think the mother later died by suicide. And I just saw it in the paper, obviously, like not reading legal journals, but that there was a successful lawsuit. So I think that, obviously you don't want to not report child abuse, but it does seem like when I read that, like you have some vulnerability if you're reporting, if there's these sort of ambiguous situations, but maybe the law is different in those states. But I don't know if you have any comment, because I mean, this comes up, like sometimes it is really not clear with sometimes like medical neglect issues really aren't straightforward and clear cut. And, we don't want to not report a situation that's unsafe, but I mean, we don't investigate, right? We just report the suspicion. So I just wondered if you had any thoughts on that.
Yeah, thank you. I appreciate you bringing that up. I'm not familiar with that case in particular. And what I'll say is I don't know whether it was a full successful case in terms of a jury verdict that was reached, or if it was a settlement that was reached. Those are two very different things in terms of a risk analysis from a health system. There is, be careful of how I say this. There is likely little to nothing that can actually prevent lawsuits from being filed. Even all the perfect consents, all the perfect steps, everything like that. We have a society where a lawsuit is a potential remedy. Now, whether that lawsuit is successful or not is a different thing. And so that's why we want to err on the side of what our duties are. If we're required by law to make a report, it's much easier to defend a situation where we say it was gray and we didn't want to fail our duty. And so we went ahead and reported versus, well, we just didn't feel like that was important, so we forgot to report that. So it becomes a risk analysis, and every case is going to be a little bit different, right? The facts and circumstances, how strongly you feel about the abuse or the neglect or different areas. And so on those really gray areas, again, we can help perhaps walk through some of those, and kind of walk you through maybe some of the risks of going which way or the other, and then give you our advice. But that's unfortunately something real that does happen, even when you take all the right steps. So I also received a question around the age of consent. Yeah, for relationships. So generally speaking, in New Mexico, the age of consent is 17. For relationships there. We do have a close in age exemption. It's written into the criminal code, just as a bit of information for you there. So it's not a legislative in the terms of this is saying that it's okay. This is protecting an individual from being prosecuted for criminal sexual penetration. And so that does exist. It's a little bit complicated. The close in age, it's also referred to sometimes as a Romeo and Juliet exception. Don't like that term because that story didn't end well, for obvious reasons. So I do refer to it as the close in age exception. Basically, if you have two individuals between 13 and 18 who are within 4 years, there is protection from prosecution in some of those situations. I will also note that when a minor is under 18, there are additional duties for consensual relationships with folks who are in positions of power. So if you have a 17-year-old who's in a relationship with a school teacher or some other individual who's in a position of power, there may be additional restrictions that are placed on those. So be aware if you have someone who is right in that 17 to 18 range, but is talking about some of those positions of power relationships. We'd be happy to walk you through some of the statutes. There's quite a few exemptions, and I didn't want to blast too many statutes at you all. But that is an area to keep in mind, is if the individual is in a position of power, there are additional restrictions on that age limit. Any questions on that one? So I believe the next area is one of the stickiest areas that I hear about, and that's divorced or otherwise separated parents and their decision making. It doesn't matter how amicable or how wonderful people are when there's divorces and decisions being made for child's medical care or psychiatric care. Things always tend to go awry quickly. And this is an area where I can only give you the lawyer's answer of it depends. Each case is incredibly fact specific and governed by the custody order in terms of where things are. And so the first step that we need to do is get a copy of the custody paperwork from whichever parent it is who can provide us that. We can try, if for some reason parents are unwilling to provide that, our office has gone on and tried to look up custody paperwork online to see if it's been filed with the courts so that we can get a copy of that. But we do need a copy of that paperwork because most will at least give us a general guideline of who is set to make medical decisions or psychiatric decisions for the treatment of a child in certain situations. They vary all over the place. There are some where it's joint, but one parent can agree, the other doesn't have to. There are some where both parents must agree or consent before treatment can be given. There are some where it's the custodial parent. So if the child is living with dad for that week, he's the one who has the decision. Each of those vary, and they're most oftentimes written by attorneys and not providers. And I feel like that's an area that I would love to teach more attorneys about because they don't work well in real life all the time. They get to be very sticky very quickly. And so we need to make sure if there ever is a situation, obtain that paperwork as quick as possible. And if there's any ambiguity, get that information to our office and we can help you walk through the ambiguities and what some of those next steps may be. Any questions or discussion around that one? Because I feel like that is always an uncomfortable and difficult area.
There is a question about that from Angelica. Just a second. She said, if we're not able to access that paperwork, or if there's not legal custody, do we default to both parents agreeing?
Yeah, great question. Not everyone has gone to court and obtained a nice, clean custody order. And so sometimes we don't have that. The default is typically joint custody. You want to make sure that we're honoring the rights of both the parent and both parents in the situation, unless we hear otherwise. And so I think that that would be our default. But again, we'd want to talk and make sure we're all on the same page and we have whatever evidence that we documented in the file to be able to support those decisions.
And Laura, you had a follow-up question. Did that answer your question? What if parents do not have formal custody agreement or they were never married?
No, that answers my question. Yeah, thank you.
I did. Okay, great. Hold on. Will you be addressing the age of consent for psychiatric treatment? I'm wondering specifically about treatment for gender dysphoria, including pubertal blockade and hormone therapy.
I can. Let me see just a moment here, because I want to make sure it can be as clear as possible. So generally speaking, a child has, I'm sorry, I'm just pulling up the documents here. I appreciate the question because I'm sure that is coming up more often nowadays. And if the computer cooperates with me, I can get to it. Right there. There we go. So consent for services when it comes to children's mental health is governed by the Children's Mental Health and Developmental Disabilities Act, which hopefully everyone is relatively well aware of, or at least knows the existence of. It's located in Chapter 32, Article 6A, 32A, 6A of the New Mexico statutes. So it's split between children aged 14 and those who are under 14 and over 14. So children under 14 years of age can initiate and consent to an initial assessment with a clinician and for medically necessary early intervention services that are limited to verbal therapy. And I think that is the extent of where things go. In fact, it says in the statute, the informed consent of a child's legal custodian shall be required before treatment or habilitation, including psychotherapy or psychotropic medications, is administered to a child under 14 years of age. For a child who is 14 years of age or older, they're presumed to have capacity to consent to treatment without the consent of their legal custodian. However, when it comes to any type of psychotropic medications, the legal custodian must be notified by the clinician that they are going to begin using psychotropic medications. Hopefully that answers that question.
Sorry,
And
can you hear me?
I can.
Just to complicate it further, is testosterone a psychotropic medication? That's the sticking point, because the consequences of gender dysphoria, if that's what we're calling it, are largely psychiatric, but the treatment is endocrinological, physiological. So there's been this question of whether estrogen and testosterone are considered psychotropics for the purposes of the law. So thank you for allowing me to complicate it further.
It's a great question. I appreciate it. Psychotropic medications is not listed under the definition section for the Children's Mental Health and Developmental Disability Statute. So I can do some research. I'm assuming it's not going to be defined in New Mexico, but I may be able to provide some guidance in terms of nationally, or if not, we can kind of work through that guidance separately. So I'll make a note on that one as well. But thank you for that clarification. Any other questions or clarifications on children's age of consent for treatment or services?
Cory, could you talk about the difference for contraception? Because minors have a specific right in the statute for contraception without informing their parents.
Yes, so under New Mexico law, any person, regardless of age, has capacity to consent for prenatal, postnatal delivery, and contraception and family planning. And so that does not have an age restriction. That is just any individual within New Mexico is apparently deemed to have capacity for that decision. And there are other, I don't know how much I need to get into. There are exceptions within the Children's Mental Health or Children's Code for legally emancipated children, and different things that they can do for that. Life-sustaining treatment, pregnancy, STIs, all sorts of different areas where there are separate consents for minors as opposed to adults. But I think at least for hopefully y'all's bulkier practice, we've covered the most pertinent.
You have a couple of questions. Again, back to parental consent or guardian consent. Can you clarify the decision making when parents were never married or separated or don't agree for emergent psychiatric hospitalization?
Yeah, that's a difficult one that I can't give you a bright line, one sentence answer for. That would be something, if you have a situation, please reach out to our office and we can walk you through what that decision is. Most oftentimes, if it's an emergent situation, we're going to move forward with a single parent. But it really depends on the situation and a lot of the circumstances and facts as to what we need to weigh and where we need to go. There's also a very big difference in general from having one parent who is consenting and participating, and one parent who has just not consented, versus a parent who has said no. So those are two very different situations under the law, right? Where we have someone who's affirmatively said, do not do this, versus someone who's just not provided the consent. So yeah, please reach out to our office because those get very sticky depending on the circumstances.
So I think I was really hoping to speak to our adult psychiatrists today who have a lot of interaction with children and adolescents in PES, and it's very overwhelming, and kudos to all of you. If it's medically necessary, this child is at imminent risk for suicide, and my sense is that first and foremost, we have to protect the child. And then, is that not correct?
No, that would be correct. And especially when it comes to risk of suicide, there are other tools that we can do that don't require consent. I know that one of the most wildly misunderstood statutes and tools for our providers is the certificate for evaluation. And what that consists of. Our office has been doing a lot of work on that area in particular, and what powers and duties we have when utilizing the certificate for evaluation. But if we do realize that it's an emergent situation and that the child's life is in danger, that is a tool that we can use to get the child into an emergency evaluation and possibly emergency treatment if it's deemed necessary. And it does not require the consent of any parent or anybody else. That's something that the statute allows. Again, a lot of nuance involved in a certificate for evaluation. I'm happy to provide more guidance on that, but in general, that is a tool that we can use if we feel it rises to that level of risk. Absolutely.
Anyone who's working in PS, do you have any questions about that? We have another question about the juvenile detention center. And the question is, let's see, Abby, your question is, we also just use whichever parent is custodian when they come into the juvenile detention center. Is that what we're supposed to do?
Well, it depends if it's a married family and the custodial parent comes in, then that's a very different analysis than if they're separated, divorced, or don't have some other situation. Defaulting automatically to the custodian for all rights and abilities is not always the right thing to do. Even though I understand in terms of practicality, it can be easier and quicker when you're time limited and there's a lot of different things that you're trying to deal with. I think best practice and what we would advise is to understand the relationship of the parents and to be able to, even if we're advising them ahead of time so they're aware, that if they can bring in custody paperwork with them to their appointment, if we have contact prior to the appointment, so that we can have that documentation and understand the situation more fully, I think would be the best way to do it.
Is that part of their file at the D home? Anyone who works there? Abby, would you know?
That I would not know.
Okay, it sure seems like it would be taking care of adolescents. Okay,
I think it just responded usually. So if it's in there, look to the documents. And again, if you need help clarifying any of the ambiguity, our office is there to help with that kind of paperwork and understanding the ambiguities there. Okay.
and if I've missed anyone's question, please. Angelica, you had another question about consent, where families, one parent's living here with the child, one guardian is here with the child, and then the other guardian is in the detention somewhere or living in a different state and unable to be contacted.
Yeah, when there's an unavailable parent, that's something we can walk through given the circumstances. Again, hard to give a blanket, and I know legal advice is inherently unhelpful in most of those types of situations because you'd like to have, the procedure of here's what you do and you're good to go. It's going to depend, and oftentimes the level of unavailability for a parent depends. There's a difference between just can't get a hold of them on the phone right now, or they're incarcerated and they can't get a decision. We can't get in contact with them at all. So that's a situation we can walk through with you if there's ever a concern around that.
Cory, in most cases, this is Avi again. What's really helpful is to document all, quote, reasonable attempts. So you can say what numbers you called, what address you tried to reach, if they are incarcerated, and document that.
Correct. And good default for most everyone is whenever you're dealing with any of these situations, document. All the emails, the different folks, who you talk to, what phone calls you made, everything like that. So if someone was to come back later on, and again, this kind of a situation that Dr. Colon was referring to earlier, where if a parent was to come back and sue us later, we can't prevent the lawsuit, but we can show here's all the things we did to try to get in contact. We're happy to include the parent now that we do have contact, but at that time we didn't, and here's what we tried, and that's why it was reasonable to move forward. So that may be our analysis. But yes, everything we can document, and a number of tries, the different ways we can try, all that good stuff. Very good reminder. Okay. So I believe in terms of the questions that were initially sent over to me, that's the information that I prepared there. I did want to leave time if there were questions on different topics that folks had that they would like to raise here. Please feel free to do that. Otherwise, I can talk about preparing for testimony or different areas that you may be contacted by attorneys, some different tips and tricks and things like that. Those are typically the other area where our office gets called or contacted. And I guess I will do a quick plug for our office. If you are contacted by an attorney for any reason, just a reminder, because I always have to include the reminder, we cannot talk to anyone without an authorization. Oftentimes they'll just call to say, I want to confirm that, my child is there. I want to confirm that my client is there, was a patient of yours. Even confirming their patient status is a release of protected health information. And in New Mexico, It's specially protected, and there's additional layers of protection around mental health records. So anytime you get a call from an attorney or from anyone else who wants to talk with you about a patient, please make sure that you have a HIPAA authorization or that they are actually authorized in some way, shape to talk to you, or send them directly over to me in our office. We handle a little over 700 subpoenas and requests for interviews and conversations a year. So our office is well versed in human rights.
Cory, could you briefly talk about what you and your colleagues can be of help if people are subpoenaed by the court to offer testimony?
Yeah, I'd be happy to. Thank you. So I think first and foremost, and I'll just kind of include some of these slides, right? First and foremost, ensuring that you all are protected in terms of the disclosure is our first line of defense, making sure that you're authorized, that you can disclose everything, you're not going to have some type of breach or issue there. The other thing that we do is we work with attorneys to help reduce the stress and load of subpoenas. So for those who aren't familiar with a subpoena, just very briefly, a subpoena is a court order that mandates that you appear at a particular time and place to either testify, provide a deposition, or to provide documents surrounding the case. Failure to comply with a subpoena can lead to being held in contempt of court. And though I've never seen it for a provider, I always have to throw out, technically speaking, there is a risk of jail time for failing to comply with the subpoena. So it is something serious. It is something that we want to make sure our providers are complying with. We do our best to, once we get brought into the loop, to accept the subpoena on your behalf. So typically, they would send a sheriff or a process server either to the hospital or your office, or sometimes to your home to serve you with a subpoena. And instead, we ask them to come to our office if you'll allow us to do that for you, so that you don't have to go through that process of being served with a subpoena. So that's our first little small thing to do there. The second one is we have a good relationship with most of the children's attorneys and DAs, public defenders, and a lot of the frequent flyers around subpoenas. So we can't always dictate the time and date, but especially for a deposition and not a court hearing, we can work with the attorney to make sure that it's as convenient as possible, even though it is a huge inconvenience for anyone being subpoenaed. So we can work with them to pick a time where you will be able to actually sit. Oftentimes, especially for those who are working nights or overnight on call or something like that, having a deposition at 8 a.m. is cruel and not nice. And so if we work with the attorneys, we can help guide some of those times and dates. We're also using a lot more Zoom depositions and Google Meets, things like that, where we can try to work with these folks to make it a little bit less of a burden on all you folks. But that requires us getting involved sooner than later. So if you get contact from anyone, direct them to us, and we will do everything we can to help you out.
And an email subpoena, because we had one of these I spoke with you about, is not being served, right?
Correct. Just getting blindly emailed a subpoena is not valid in New Mexico. Unfortunately, there is law that if we use a fax number on our letterhead, that receiving a subpoena via fax can be considered good service. So sometimes if that comes in that way, it is valid. But again, our office can jump in, and sometimes we'll have them move it or change the subpoena once we talk to them. So it's not always written in stone, but we do our best.
But if there is an email subpoena, even though it's not a subpoena, it's really important to reach out to Cory's team and be a part of this, because you're very likely, if you, once they coordinate actually someone being served, you will have to testify. So reach out to them, they'll walk you through this.
Exactly. If you get a subpoena by email, they're on their way to serve it.
It's, yeah,
So
it's imminent.
we can help. It's coming.
It's coming.
There is some information here on the slide as well about travel. Again, we try to work with, sometimes you're going to have to travel. Sometimes you can get out of it. Out of state things are typically very different versus in state. So all little things that the more information, the sooner we get involved, we can protect you and help you. And I think that's kind of just a basic rundown of what to expect with a subpoena. I do personally meet with anyone who has questions prior to testifying. I'd be happy to walk you through what it's going to look like, what you should expect, what your testimony should consist of, what are some things that you can limit so that you're not exposing yourself during testimony. And I'm happy to have those conversations again once you get our office involved. My admin will do a good job of setting those up and making sure you're prepared as much as possible. Last, I guess, plug, since we're running real close to the time here, is the other way you might get in contact with our office is on the side of the medical malpractice or claims team. Oftentimes when we receive some type of claim, we have a duty to preserve documents and not delete them or change them in any way, shape, or form. And so sometimes you can get an email from our team concerning a lit hold or a litigation hold. That comes from our internal team. We're here to help you. It doesn't mean you're being sued. It does not mean that you are a part of the litigation. It means that there's some reason we think you might know of or be aware of some documents. And so we send it out, shotgun effect. Please feel free to contact us to respond to those so that we can make sure to walk you through what next steps are required, if any. But that's not something to be afraid of. Again, it doesn't mean you're being targeted or you're being sued. It's just our team gathering information, wanting to make sure we protect everybody the best way. So they always ask me to make a little plug for them. They're not the scary attorneys, they're the good ones.
Wonderful, thank you. So I put in the chat how to contact you on the Tiger app by attorney, and in the Tiger on the website. Remind me how do we track you down?
I believe last I looked, it's at the very top, Administrative Office of University Counsel. So we're the first one on the website if you're actually using the web portal there.
So the app is always a good default. Yeah.
App is easier.
Okay.
Sarah's on call till Monday, so if you got anything this weekend, flood her. That's fine. I picked up on Monday, so please get everything out of the way this weekend, and I would appreciate that.
Awesome. Well, thank you, Cory. We sure appreciate your time. This has been really invaluable. And then we'll follow up and any information we need to disseminate to everyone regarding some questions. I'll make sure we follow up with that.